A federal judge has thrown out a lawsuit that accused Google of using its facial recognition software to collect and store user data. The lawsuit, filed in 2016 in Illinois, alleged Google violated state laws by collecting biometric data without user consent. Now, that data was then taken from pictures stored in Google Photos. Now, the plaintiffs wanted more than $5 million in damages for the hundreds of thousands of users that it affected. They claimed that the unauthorized scanning of their faces was a violation of the Illinois Biometric Information Privacy Act, which completely outlaws the gathering of biometric information without consent. To discuss this major win for Google, we're being joined now by investigative journalist Ben Swann. Hey there, Ben. So talk to me about this. What sort of precedent could this win be for Google and for other tech companies and their use of our biometric information?
Yeah, unfortunately, I think that this goes a long way to protecting and helping Google. For instance, this law that was essentially the lawsuit was brought over was from the state of Illinois, as you mentioned. It's the toughest biometric privacy law in the entire nation. And that's very significant because essentially, if you go back and you read the law, it does not say that a person has to be damaged by the use of their biometric or the gathering of their biometric information. It simply says that to collect it without authorization is in and of itself a damage to that individual. And yet the court has now ruled that that's not the case, saying that because there is no concrete damage being asserted by the plaintiffs here, that Google did not break the law. So the judge essentially, I'm not a lawyer, but it looks to me like the judge essentially rewrote the statute in Illinois.
Right. You know, I kind of understood it the same way. I'm no lawyer. Neither of us are lawyers here, but I kind of interpreted it the same way, that I thought the law in the book said that no company shall take the biometric data of any person's, period. And thereby doing this, Google has broken that law.
That's right. And it's also important to note that the statute itself gives very specific information as to what constitutes that biometric data, and that includes facial recognition software that actually scans and takes measurements of your face. It's essentially what Google uses for that technology. So it's very specific here. It's also important to remember that lawsuits in Illinois have been filed not just against Google, but also Facebook and Snapchat for the very same reason. And those other two cases are still pending. But the fact is this: because Google prevailed, the others will likely prevail as well if they go through the same judge. Now, if they go through a different judge, maybe they don't prevail.
Now, I'm glad you brought up Snapchat and Facebook and what have you, other social media stuff, because it's important for us to talk about why the average American should care about this. Can you talk to us about why this is important to any average Joe watching this?
Yeah, well, I think it's very important for a number of reasons. And one of the reasons why is because if you are sitting there at home and you say, well, it doesn't really matter, I guess I'm not really being hurt by this. The problem is that what the court has decided, the problem is that what everyone else is deciding is that essentially your data, your biometric data, is not yours. That it doesn't actually belong to you, that it is available, that it is free to be used and free to be taken at any point by anybody. And so I think the reason this is important is because the question simply becomes this: do you have a right to your own image? Do you have a right to your own biometric data, or is it simply available for anyone to take? Even if the state law says it's not. The judge in this case said it is. It's available to be taken and to be used at any time.
But now, I got to talk about the flip side of this. I got to be devil's advocate here, because can't we argue for the company side that if you use their platform, you use their product, you use Facebook, you use Instagram, you use Google Photos, Photobucket, let's go back, 15 years. But if you use their stuff, couldn't we argue that somewhere buried in their privacy usage disclaimers that you've signed away all of your rights and they'll do whatever they wish with your face?
Right. So yes and no. So yes, in that terms of service, which we all sign every day. It's funny, my wife loves to try to read the terms of service, right? She tries to go through pages and pages of it, and I'll tell her, when you get to the end, if you find something you don't like, are you not going to sign it? And she's always like, no, I'm going to sign it anyways, right? It's going to happen. But here's the thing, is the terms of service issue is one. Yes, it might be somewhere in this fine print, but again, let's go back to the Illinois statute. The Illinois statute specifically says that that the users who are having their information collected or having that biometric data collected have to have an explicit warning that it's happening. And so burying it in those pages does not constitute an explicit warning. It has to be done in a way that says, we will be doing this with your image, we will be gathering this data. And it also states, by the way, the Illinois statute, that no private entity, which Google is, can profit from it. And Google profits from it every single day. Yeah. Again, the law specifically says you cannot make money off this, Facebook, Google, Snapchat, and yet they make money off it, and the judge overruled it.
And last but not least, our very Orwellian future, it sounds like. Do we have any escape, any reprieve from companies like Google scanning and taking our biometric data?
So in the short term, I'd say no, it's only going to get worse. But in the long term, it's possible. And a lot of people who would say, well, the technology's here, it's just going to be here. But I think at some point there will be a backlash to it, and a backlash that says, you know, do you have the right to be forgotten? Essentially, the law that exists in Europe that was established in, the 1600s, you have a right to be in a private situation. And at some point, I hope, we have a backlash. But at this point, I'd say at least in the near future, it's not going to happen.
All right, we got to sit and wait for some more precedents to be set. Thanks, as always, for joining in the conversation today, Ben Swann.
Hey YouTube, thanks for checking out our channel. We hope you enjoyed the video. We have tons of content for you just like this. For more of RT America's one-of-a-kind news and analysis, be sure to subscribe and never stop questioning more.